Welcome to the Real Estate Espresso Podcast, your morning shot of what's new in the world of real estate investing. I'm your host, Victor Menasce. I'm best known as the host of the Real Estate Espresso Podcast, but by day, I'm senior partner at Y Street Capital. Our organization develops real estate across North America. We're engaged in multifamily apartment projects, senior housing, development of subdivisions, self-storage, commercial storage, just to name a few. We have several new projects this winter that have opportunities for accredited investors located in the United States. If you're interested in learning more, send an email to info@victorjm.com. That's info@victorjm.com. This is not a solicitation for investment. Any investment would be limited to qualified investors and by prospectus only in compliance with SEC regulations. Now, in today's show, we're examining a legal case involving Nick Sirianni, head coach of the Philadelphia Eagles. Nick is best known for leading his team to this year's Super Bowl. Now, the Eagles did not win the Super Bowl as a result of a field goal by the Chiefs in the final seconds of the game. But no matter what happens on the field, Nick Sirianni has already made a huge impact in the world of real estate, winning a court case that could have national implications for sellers of property. This precedent-setting case could affect disclosures of all types affecting the quality of a deed. In January, Sirianni thwarted a trick play attempted by the sellers of a home that he had agreed to purchase. In the process, the New Jersey court gave homebuyers across the nation more protection against secretive ploys like this. The coach sued to break a contract for a house that he'd purchased after discovering the seller did not disclose a right of first refusal clause attached to the property. The clause meant that when Sirianni decided to sell the property, he'd have to offer it first to the seller's children and then to the family trust. The sellers included the clause in the title, that is in the deed, after Sirianni asked for it to be removed from the agreement of purchase and sale. Sirianni picked up the blitz and he decided to back out of the deal. The property in question is located in Morristown, New Jersey, outside Philadelphia, and it boasts 7,800 square feet of living space. It had a $2.3 million price tag, and it was described as a private oasis with a breathtaking backyard, a saltwater pool, and a hot tub for relaxing after a hard day at work. This means that for the first time in New Jersey, and perhaps the U.S. as a whole, a court held that a seller must now disclose the right of first refusal before going under contract, and if they fail to do so, the buyer can terminate the contract. For the Eagles coach, the winning drive resulted in recouping his $100,000 deposit, plus reimbursement for all of those fees that come with buying a home, including the appraisal and all of the other fees that he spent prior to closing. The judgment was handed down by New Jersey Superior Court Judge Eric Fickrey. He ruled in favor of Sirianni and his wife Brett in the court decision that ruled home sellers have to disclose if an outside party has a right of first refusal in a real estate sale. Attached to the property was this right of first refusal that the Sirianni said was not initially disclosed. The clause, which was attached to the property by the previous owner, stated that any future agreements for the sale of the house must be offered first to his daughter under the same terms and then to his son, and if both of them declined, then finally to the family's trust. That right of first refusal would remain with the property if the Siriannis purchased it. And this is where it got sneaky. The Siriannis asked for the clause to be eliminated, and they did eliminate it from the agreement of purchase and sale, but they kept it embedded in the deed. So when the Siriannis refused to close on the property, the home was ultimately sold to a different buyer for $1.95 million, $350,000 less than the Siriannis had offered. The seller then subsequently sued the buyer for breach of contract. Now, a head coach is pretty skilled at navigating rules. He might not be a lawyer, but he needs to think like a lawyer in order to be effective in his role as head coach. And naturally, as you witnessed in the Super Bowl, he's highly competitive. All of these qualities, I'm sure, played a role in him prevailing in the case. After nearly 2 years in the courts, Judge Eric Fickrey sided with the Siriannis in a decision that was handed down on January the 6th. Now, legal experts examining the case could not find a case that had the same conclusion in their search in New Jersey, in the U.S. Court of Appeals for the Third Circuit, or in fact in any court across the country. Now, I personally think the implications of the case go beyond a right of first refusal. The right of first refusal affects the quality of the deed, but there's other things that can affect the quality of a deed as well, like, for example, an easement or a servitude. Failure to disclose those could have the same impact as a right of first refusal if it's attached to the property. I think it's a very important case and puts more onus on the seller to disclose. I think that's a good thing for the industry as a whole. As you think about that, have an awesome rest of your day. Go make some great things happen. We'll talk to you again tomorrow.